Hi, everyone. Welcome to our final presentation in the class ethics. My name is Chelsea Brown, and my presentation is going to be based on criminal defense attorneys and are they ethical? So for a short introduction, today we gather to explore the power of ethics and how it pertains to the daily life of criminal defense attorneys. The reason I chose this topic is because my first jury duty assignment was a criminal case. And in that case, the entire time sitting in that courtroom, I was questioning if the man that was representing the defendant, who was accused of a very heinous crime that most would agree in a moral aspect is not very well. The case was based around rape. And that entire time, I questioned if the criminal defense attorney was ethical in defending this man, even after all the evidence, and if this man was going to be found guilty or not. So using outside sources and textbook findings, it will assist in solidifying the definition of ethics within the criminal justice system, specifically with criminal defense attorneys. So first I have the agenda where I will speak about negotiation and plea bargaining, client care, ethical responsibility, moving on to ethical principles, the duty of candor, and then a conclusion. Of course, there's going to be some slides that are backed off of the main reasoning, but moving on. So first, we have the ethics behind negotiation and plea bargaining. So with negotiation, this is when defense attorneys analyze the strengths and weaknesses to a case to negotiate the best resolution for their client. Some of this with negotiation, a lot of the times it has to be passed through with the family, depending on the severity of the case, and it also has to be approved by the judge if it is that severe of a case. The same goes with plea bargaining. If it is a extremely heinous crime, sometimes it is not as simple to just create a plea bargain based on the wants of the defendant. And plea bargaining contains potential benefits such as speedy trials, harsher sentences, and avoidance of emotional tolls for the defendant. And that's where the family can come in and agree or disagree that this plea bargain should be acceptable in certain circumstances. So moving on, is it ethically proper to represent a client accused of a criminal offense when the lawyer knows the client is guilty? Firstly, defense counsel must strongly discourage the defendant from perjury in testifying. In model rules 3.1, 3.3, and 6.2, the standard is set for ethical laws that a lawyer is not permitted to defend a proceeding unless there is a basis for doing so. And this basis, it cannot be considered frivolous. Moving on, the adversarial system requires lawyers to present a fearless defense for their clients. And lawyers may argue that they are simply fulfilling the aims of that system. From the perspective, the lawyer is a functionary in the system. So I have highlighted the main points of this paragraph. The first being certain not merely of guilt, but that a conviction will be obtained. So the defense attorney is not fighting to say that this person is innocent, but they are fighting to ensure that the conviction will end up in the trial and benefit to the defendant. They are not trying to prove guilt or prove innocence. They are proving and showing the facts and the evidence of the case. As well, they uphold the human dignity of that person. Yes. And they do not sit judgment over them because in a case, it is not, the defendant is presumed innocent until proven guilty. And proving that guilt or innocence is not within the lawyer's function. So moving on, we have client care. So firstly, they offer client counseling and emotional support to the defendant, as well as clarity and understanding, which makes the defendant feel as if they are in a more comfortable space and able to talk with their attorney without fear of implementing themselves or anything of that sort. The defense attorney can also offer support groups to help with emotional cope because the trial can be very demeaning on a defendant and their families. Overall, the support provided by criminal defense attorneys navigates the legal complexities while also offering guidance and support. It allows the client to navigate the legal system with confidence and resilience. Moving on, we have the importance of legal ethics in criminal defense. So first we have the Balancing Act. And the Balancing Act is, pardon me, I lost my train of thought. The Balancing Act navigates gray areas where legality may conflict with personal beliefs or societal norms. Moving on, there's controversial cases. So like I mentioned in the beginning, the case of rape, or maybe if someone's being accused of pedophilia, anything of that sort, defending clients involved in controversial cases poses unique challenges that require careful consideration before obtaining this case. Also, there are ethical dilemmas. They have to be able to differentiate their ethical morals with the case that they are fighting, and as well personal beliefs, which can tie into Christianity, any religion of that sort. They have to highlight the need to separate their personal opinions from professional responsibilities. Overall, defense attorneys have to maintain their professional integrity, but also protect the rights and well-being of their clients. Ethical considerations guide every facet of the criminal defense process, from evidence gathering to courtroom argumentation. Ethical attorneys prioritize the best interests, working to protect the defendant's rights within the boundaries of the law. Moving on, we have the ethical responsibilities. These are the main responsibilities that I have discovered in my research process, which is integrity, confidentiality, loyalty, and justice to all. So integrity, basically this means that they conduct themselves with honesty and transparency while maintaining the highest ethical standards in all interactions. They present truthful information and avoid misleading tactics. Moving on, we have confidentiality, which builds trust and fosters an environment where clients can discuss the case without fear. And then there's loyalty. They remain loyal to clients' interests and advocate endlessly on their behalf while respecting their autonomy and decisions within the bounds of law. There are special circumstances where they legally cannot respect the client's wishes, but overall they uphold the principles of due process, fairness, and the presumption of innocence. And justice for all safeguards the rights and interests of individuals accused of criminal offenses. Legal knowledge, strategic planning, advocacy skills, and unwavering commitment to protecting the client's rights. Moving on, we have ethical principles. So first, we will start with due process. The due process contains thorough investigations and presentation of evidence obligated to conduct thorough reasoning on behalf of their clients. It involves relevant evidence, such as interviewing witnesses and examining the prosecution's case critically. Moving on, we have zealous advocacy. Zealous advocacy means that the defense attorney must not engage in conduct that would undermine the integrity of the legal system. This includes false evidence, subverting perjury, or engaging in unethical behavior. Last, the duty of candor balances zealous advocacy and due process. It must uphold fairness, truthfulness, honesty throughout the legal proceedings. Moving on, this term is actually from the textbook, and it is called categorical imperative, presented by Kant. That is his last name. And the main part of the categorical imperative is to be helpful to people regardless of your particular wants and desires. And this shows a lot on the defense attorney's end, because whether their moral beliefs align with the case that is being presented to them, they are helping this person because everyone deserves representation. Everyone deserves a chance to be proven, to have their evidence proven or given to the court in a legal manner. One case study that particularly stood out to me was case study 1.2, the police brutality during Katrina. In this case, after Hurricane Katrina struck, New Orleans police shot 6 civilians who were crossing the Danziger Bridge. In August of 2011, one of the officers, Michael Lohman, admitted to organizing a cover-up of the incidents because he recognized it was a bad shoot. The retired sergeant and the 4 other officers planted a gun, fabricated witness statements, and falsified reports after they had shot unarmed civilians during this time. This directly brings us back to duty of candor. These police officers violated the duty of candor by leading with misleading tactics, falsifying evidence, testimonies. They weren't truthful and they weren't ethical with their response. They made a mistake, a very bad mistake, and instead of ethically and morally owning up to their mistakes and their wrongings, they falsified a court case and blamed it on someone else. Moving on, we have faith and ethics. I have 2 quotes here that specifically stood out to me in the textbooks, and one is with trust within belief. The quote says, "Trust is an aspect of professionalism, and the encouragement of trust has become a fundamental characteristic in professional relationships because clients depend on the superior knowledge of the professional." Trust within your own faith to be able to work with someone that is being accused of a criminal activity or misdemeanor is very important. You have to be able to differentiate your faith and your trust of your personal life between the trust with your client. And is this a violation of their faith? This quote says, "If the moral of a particular society determines that a certain act is right, then the act is right within that society. Accordingly, it is not for us to judge other people's conduct in other societies. We should be tolerant and avoid being judgmental." This goes to show that judgment is not okay, even if the defendant is in court and all the evidence is pointing towards them. It is not the defense attorney's right to point judgment or shame that person. Their only reason to be there is to fight for the defendant and provide the evidence and whereabouts, etc. And ending off with the conclusion, after a lot of extended research with outside sources and the textbook, it is not the attorney's job to decide whether the defendant is guilty or innocent, rather than present founded evidence and circumstances to assist the judge and jury to decide. There are complications between the attorney's morals and the cases they are defending. However, the legal actions and responsibilities they follow does not differentiate how ethical the attorney's ethical or moral sense can be. So overall, a defense attorney is not unethical or violating morals by defending an accused person. Here I have my resources that I used, and thank you. I hope you guys all have a great winter break. Merry Christmas, Happy Hanukkah, Happy New Year.